Appeal, Super Industrial Services Limited and the National Gas Company of Trinidad and Tobago.
My Lords, my Lady, in this matter I appear with Mr. Rupert Allen and Mr. Jason Mutu for the appellant, who's also the claimant. Mr. Peter Knox, Queen's Counsel, and Mr. Robert Strang, on our side, appear for the first respondent, and Mr. Ramesh Maharaj, Senior Counsel, and Mr. Tom Poole appear for the second respondent.
Right, well, shall we start with a little bit of case management, since this is what this case is all about? And
I object to that.
Since having read Chief Justice Sharma's foreword to the rules, which are the source of all the issues, I am reminded that case management involves active intervention by the court, and also the proposition that cases should not be left in the hands of the lawyers to run as they wish. So what is this case all about? Well, at the end of the day, I mean, you presented us, both of you, all of three of you, with fascinating arguments, at least a legal enthusiast might describe them as such, about the meaning of the rules of Court of Trinidad and Tobago. But the ultimate shape of the case appears to be perhaps overlooked. This case began before the judge, as we understand it, with, on the one hand, the proposition that it had been automatically struck out, but on the other hand, an application, if it had not been automatically struck out, for relief. The Court of Appeal has affirmed that such an application, including an application for an extension of time, would be perfectly permissible. But when counsel at the end of her argument in the Court of Appeal raised this, the Court of Appeal said, oh, well, the application was withdrawn. That is an incorrect, it appears to us, categorization or description of what had happened, because on the basis the judge decided, the application couldn't exist in law, because the judge had held that the relevant rule, striking out automatically, didn't apply, and so there's no basis on which you could apply for relief. So I don't know what withdrawn means. We haven't been blessed with any of the transcript of that particular hearing, or with any basis for the word withdrawal. Whether it was used or not, I don't know. But whether it was used or not, it clearly cannot have meant that counsel didn't want the discretion exercised in her favour if it was necessary. Yes. And she raised it in the Court of Appeal. The Court of Appeal, having concluded opposite to the judge that there's no automatic striking out, why didn't they?
There is.
Sorry, there is an automatic strikeout, yes. Opposite to the judge's conclusion that there was none, concluded that there was an automatic strikeout. Why didn't they remit it to the judge, at the very least, for her to determine whether there should be relief, that application now coming to light? Why didn't they decide that application themselves? And why shouldn't any appellate court, since all the courts have the power of the court below, decide so? You don't appear, none of you appears to have addressed any observations to this aspect at all. The other aspect which concerns us is what is this all about in this sense, that this was an application for Moreva relief, which was granted. Effectively, that's the end of the case, and Lord Hughes tells us that there is some authority in the county court, in relation to county court jurisdiction dating from the 80s, which might have been relevant as to whether that had some effect on automatic striking out. But leave that aside. Assuming there was an automatic striking out, what would prevent another application for Moreva relief now? As far as we can see, nothing, but you may, the assets have all been frozen for years now. So the shape of this litigation, if one looks at it slightly wider, really escapes us, and we wonder whether you oughtn't to take some time. I don't suggest an adjournment, but a few minutes just to contemplate whether it's really focused correctly at the moment. Obviously, we will do our job and decide issues which are relevant, but at the end of the day, we have to decide, if we uphold the Court of Appeal, what order follows, whether it's the order which the Court of Appeal made, and it may be at that stage you either have to go back to the judge or we have to exercise our powers to decide whether relief should be given, as was originally applied for.
Well, may I think about that, as you've invited us to do? Certainly, I can't see that we could object on our side to
it's not. These are points which I'm not surprised you don't object to. It may be that your learned opponents would like some time to think about it, and we're not suggesting more than a few minutes, but it may be the shape of the case has escaped us, but we like to think that cases are focused to achieve an ultimately just result, and as far as we can see, the Court of Appeal, the majority, was fully aware that it was reaching a result which was unfair on the particular facts. It felt constrained to. I've suggested that its reasoning on the ultimate order it made may be open to some doubt, but it may be like to have a small thought about this, because I think we're not going to be happy about deciding the case on the narrow, or however fascinating and however important procedural point about whether there's an automatic strikeout in the present circumstances. So would you, Mr. Maharaj and Mr. Knox, do you want a few moments just to collect your thoughts after that exercise in judicial activism?
Yes, I will do that.
Well, we'll give you 10 or 15 minutes if you...
15 minutes?
15 minutes, yes. Do you believe that? Yeah. And we'll try and help you. I don't suggest you devote too much attention to this, but maybe a junior. The right case is apparently...
Well, I'm not so sure that you should use the next 15 minutes for this purpose,
Next.
gentlemen. But if and when this case is ever fully argued, it would help at least me to know whether you'd considered whether any of the legion of cases which County Court Order 17, Rule 11 generated has any relevance, including the ones which appear to say that the automatic directions for which it provided, which were not in the same terms as these, quite, were simply ousted where there had been an application for an interlocutory judgment. Still less what looks to me very like a final judgment. Anyway, but not now.
Yes. Well, we'll adjourn for at least 15 minutes. Let us know if you want a few minutes more. Yes, Mr. Knox.
Well, my lords, we obviously oppose this method of procedure, if I may respectfully say it. If I can just outline why in a few words. The application for relief from sanctions was made in writing on the 7th of June 2010. It's not in the record.
7th
of June.
7th of June 2010. It's, 16.
16 it'll be.
It's not in the record.
Yes. Well, that was a point she made in the Court of Appeal. Said for some reason it's not, but well, so it's still not. Yes.
For some reason, I'll explain the reason.
Right. Okay.
The order was made. The judge on the 10th of June made an oral, or gave an oral judgment and made an oral order, where she indicated that, as far as she was concerned, the case had not been automatically struck out. Whereupon, to the best of the information we have, but it is at the moment entirely incomplete, the respondent withdrew its application, or asked for permission to withdraw its application for relief, and the court gave that permission. And you can see that, you can see the court order recording the permission to withdraw with no order as to costs in the first bundle of the record at page 357 at the foot of the page, or if you're looking at the MS numbers, 359. The judge made a number of orders on the 10th of June, but one begins at page 355 or 357 in the MS, and the relevant passage is at 357 or 359 on the MS, right at the end. Further, hereby ordered, permission is granted to withdraw the notice of application, no order as to costs. Now, in her judgments, the judge gave two judgments on the 21st of June. She refers to it in her she refers to the application itself in the second of her judgments, which is the automatic strikeout judgment, and you can see that in the second part of the record at page 389 in the page numbering, or 391 of the MS record. In paragraph 16.
That's the judgment on the merits, isn't it?
Sorry?
This one's the judgment on the
I think actually it's on the strikeout point, but I might be wrong, my lords.
I beg your pardon.
She does deal a bit with the merits as well, but this is,
You're
I
quite
think,
right.
specifically with the more specifically with the strikeout.
Thank you.
Yeah, so it says seeking, application filed seeking, yes, and then
In paragraph 16, she refers to the application,
yeah,
especially the last 4 lines,
Yes.
5 lines. But she doesn't deal with it. She says nothing about it. And she deals simply with the automatic strikeout point. We then appeal, and there's no respondent's notice seeking to uphold the judge's order on the basis that she could have come to it anyway, or should have come to it anyway, on the basis that she should have granted relief from sanctions. Because the effect of the judge's order, the claim is not struck out. We say she should have held it was struck out automatically. The obvious course for the respondent at that point was to say, well, if that's right, then we should have relief from sanctions in any event.
wouldn't the alternative be to remit for dealing with the outstanding issues, or the issues which should and would have been outstanding had she come to a correct decision?
Well, they could have done that, but I submit a simpler way of doing it would be to say, well, if the judge below was wrong and the case had been automatically struck out, she should in any event have acceded to, and she should have given judgment on.
But she hadn't exercised any discretion, so that they would be effectively then asking the Court of Appeal to deal with part of the case she hadn't dealt with.
Well, my lords, that would have been another way of dealing with it. They'd either say the Court of Appeal itself should deal with our application for relief from sanctions, alternatively it should remit the matter back to the judge.
Well, isn't that what she did say, Mrs. Peake, senior counsel, at the end of her submissions before the Court of Appeal?
Well, there was no respondent's notice to that effect, and I submit it's important.
The rules require a respondent's notice to them.
Oh, certainly they would, yes.
Have we got them?
Not that one. I've got they're all here.
They're all here.
I'm fairly sure from experience.
Yes, quite.
It's like ARP system. You can't
Right.
just sort of turn up and say, oh, well, would you mind upholding this judgment on some other ground?
But I suppose there is a question, as if all you were going to say was, right, you dealt with the immediate issue, now we should deal with the outstanding application which didn't arise on the basis on which the judge below dealt with the matter. Maybe you wouldn't need a respondent's notice for that, I'm not sure.
It could be dispensed with, I suppose. But
It
you might need to marshal some material in response, I suppose. But you wouldn't know until you'd seen the judge's judgment on the merits, would you?
No. And we would obviously want to say something about it. But it's not just the respondent's notice point. It wasn't in the written arguments either.
No, I see that.
I'm absolutely nowhere. So, and I think I'm right in saying it is raised near the end of the respondent's, the appellant's submission.
Well, that's my understanding, but I may have missed something in the earlier part, but I don't.
And what happens is, my lords, I think you've obviously seen the references. I can just check. I don't know if you've got the supplemental bundle to have.
Yeah, we certainly have. No, it's page, well,
It's
287.
Page 287, looking at the small numbering at the foot of the page of the hard copy. Yeah, yes, 1541 in the MS.
But they don't seem to have dealt with it on the basis that it hadn't been, it couldn't be raised. They dealt with it on the basis which that it had been withdrawn, which may technically be correct, but there actually wasn't anything on which it could bite. So withdrawing it was inevitable on the basis of the judge's judgment, wasn't it?
Well, it appears that it was expressly withdrawn. Permission, you'll recall what it is recorded in the judgment, permission to withdraw. It sounds as if, very much, looking at this, and indeed at the judge's order, that there was a specific application to withdraw the application, and permission was granted to withdraw it. I mean, otherwise, the order would simply have said no order on the application for relief.
Yes.
So I submit...
You say there should have been an appeal against, that?
Respondent's notice.
Respondent's notice. I mean, it was inevitable in the light of the judge's judgment, one could say, because there wasn't anything to pursue, actually.
Yes,
a basis.
Yes, if the judge's judgment was right, but if it was wrong, then there was another way of upholding the effect of her order, namely the action's not struck out because relief is granted. Now, my lords, it goes a little bit further than that, if I may, with respect, say, because, of course, the matter is not dealt with by the Court of Appeal in its judgment, and I submit perfectly understandably, bearing in mind that if one sees page 288, halfway down the page, Justice of Appeal Nareen says, but the application was withdrawn. I don't see how we can deal with that. Ms. Peake, well, it was withdrawn, my lords.
Because the judge found the matter was not automatically struck out.
Yes.
This is at the stage where judgment's been reserved, isn't it?
Well, she'd given an oral judgment.
No, this is in front of the Court of Appeal.
Oh, yes, that's right, yes.
And they've reserved judgment.
They themselves are judged, yes.
So no one yet knows whether the issue of the application for relief is going to arise or not.
No. But you'll see a little bit further down the page, Mr. Justice Nareen, yes, but Mrs. Peake, how, first of all, it's not before us, it's not clear, it doesn't form part of any submissions before us on the grounds of appeal. How can we treat with that? I'm sorry, I don't see how. Mrs. Peake, well, my lords, perhaps we could deal with that. Let's not speculate, we'll deal with that at the appropriate time. Now, sort of left in limbo. Now, whether she meant on the handing down of judgment. Now, my lords, if I may just come back to this in a moment, because something has happened of which you are unaware, because what happens, I'll come to this in a moment, what happens is that on they apply for permission for special leave to appeal to the Court of Appeal, and they are granted that special permission. They're granted special leave because the case, on the matter which is currently...
Special leave to come to Privy Council?
Yes, because, of course, it's a purely procedural appeal.
Right. No, we wouldn't normally.
And the point taken is that there's a point of great public importance in the proper construction of Rule 27.3 and so on. There's absolutely no reference at all to whether or not the court, in any event, should have allowed the application, or rather dismissed the appeal on the basis of, or rather remitted the matter to the first instance judge. There's no suggestion the Court of Appeal went wrong in that respect. But there's no suggestion either in the notice of appeal to the Privy Council or in the written case to that effect. And what, in fact, the appellants did was apply on the 27th of March. You won't know this, nor maybe I don't know if it's in the record. They did apply on the 27th of March last year for application for relief from sanctions to the first instance court in the event that their appeal here is unsuccessful. So what they have done in my submission is consciously follow a course, which is, if they lose here, they will then ask the first instance court for relief from sanctions. That's the course they've adopted. They've consciously not adopted a course of asking your lordships for relief from sanctions or to remit the matter to the first instance judge for relief from sanctions. And we have defended this appeal entirely on that basis. And I do...
I suppose you'll probably defend the application for relief to the first instance court on a different basis, won't you? You'll probably say it's too late.
We will no doubt take point... I'm not instructed at the moment to appear on that, but one can imagine the types of submissions that would be made. Now, they may or may not succeed. Like you had your chance, you've taken a course which, for whatever reasons, was the one you wanted to. It may have been a misconceived course.
Well, it'd be a sort of Henderson and Henderson type point. No doubt a principle designed in the interests of justice as well.
Undoubtedly. My lords, no doubt. I mean, of course, this case in one sense is at the crossroads between that. I mean, you can always say, well, hard cases make bad law, and so forth. But, my lords, we do make just a couple of observations. First of all, we say, how can it be said the Court of Appeal's judgment or order was wrong, given the issues before it? Subject, of course, to the main point in this appeal. How has the Court of Appeal gone wrong in not upholding the judge's judgment on the alternative grounds that relief from sanctions should have been given, or in not remitting the matter, when it wasn't asked to remit the matter to the High Court? So we say there's no basis for saying the Court of Appeal's judgment was wrong. Secondly... Well,
courts don't always have to proceed on precisely, especially in the light of the overriding objective and the principle of court management. But
I accept that, my lords. But there is another point, my lords, on which I would certainly would have liked, and I'm not asking the time now, but there is a question about jurisdiction of the Privy Council. Now, this is a point which, in one sense, you yourselves don't have original jurisdiction. My lords, you'll recall there were various cases about to what extent does the Privy Council have original jurisdiction to make an order.
Right.
Which was on an issue which is not properly before the lower court.
Well, I think we have all the powers that the local court had, the Court of Appeal under the Trinidad and Tobago Constitution, don't we? And likewise, we're told in this passage in the argument that the Court of Appeal had all the powers of the first instance court.
Yes.
So, we can look up the Constitution, but that's my recollection.
My lords, I think the only other point is there is perhaps a degree of prejudice, and the point being taken now in this way, because we simply haven't had time to investigate exactly in what sense the application was, quote, withdrawn below. We have seen in the application I referred to, the 27th of March 2017, it suggested that what happened was the application was withdrawn once the judge had given her oral judgment.
Yes.
Now, my lords, none of us was there at the time. Whether that is the precise sequence of events or not, we don't know, and in what terms it was withdrawn, we don't know.
Well, it would seem, that was the order of events you've just given us. You used the judge made the oral order that the case had not been struck by, whereupon the respondent asked for permission to withdraw, and the court gave that permission. It would seem to be overwhelmingly likely to be the position there would be absolutely no motive for prior withdrawal at all.
Unless, of course, counsel thought things were going so well. She didn't want to take any more risks with costs and so forth.
Not what she said to the Court of Appeal, is
no.
it? It was withdrawn because the judge didn't think it was necessary, because it hadn't been struck out.
No. Well, my lords, I accept that's what she said. It's just simply that we haven't had a chance ourselves to see whether there's anything more to it.
And is the application which you said was issued in a conditional sort of way on the 27th of March of last year, is it simply an application notice? There's no evidence or anything? What state is it in?
I'm told it's supported by an affidavit.
Supported by an affidavit and presumably adjourned to await the outcome of...
Yes.
Has it been before the judge at all?
Not that I know of, no. But, my lords, I submit that is the rather trickier point. And I submit the better point we have is that this is a conscious choice not to take the point before the board. And indeed, it would seem really before the Court of Appeal.
Can you address the other point? I mean, is there any possible reason why these orders couldn't and shouldn't be renewed? I'm not sure under what jurisdiction they were made, presumably the equivalent of the Supreme Court Act or something, giving power to make orders in aid of arbitration, similar to we have under the Civil Jurisdiction and Judgments Act, I think.
My Lords, of course, I would accept on the face of it that the effect of the strikeout is simply that. It's not an adjudication on the merits and therefore would not prevent the appellants coming back to the court. Let's say the case is now struck out.
Yeah.
The appellants could come back and say, well, we want another freezing order, thank you very much. But, of course, there would be cost consequences. You normally cannot bring a second action, whether you've discontinued or been struck out, without paying the costs, defendants' costs, successful defendants' costs of the first action.
And is the arbitration carrying on, or...?
I'm not... Right, the process has been started, but it hasn't yet, the actual hearing hasn't begun.
Yes. Right, well, unless there are any questions, that's very helpful. Thank you. We'll hear from Mr. Maharaj, shall we? Yes.
My Lords, we respectfully agree and adopt submissions made by the first respondent. But I merely wanted to point out that this is an issue in which the appellant has decided and has defined the issue for what the Privy Council has to decide. In the application for conditional leave, and based on the order which the Court of Appeal made, and if I can refer your Lordship to page 1755, MS page 1126. The questions.
So which bundle is this in?
That's volume 2, my Lord.
MS page?
MS page 1126, my Lord.
And what, do we have a...
Volume 2, my Lord.
Do you have a written pagination there? Is it the same number? I doubt it. They're
pages
cunningly designed.
Wrong.
Tab 24.
No tabs, I'm afraid.
24. Sorry, my Lord.
What is this in?
No tabs, no page numbers.
I have it in volume 2, my Lord.
Yes, I've got it.
Yes, my Lord. Yes, my Lord.
Yeah.
I have one. Yes. One.
The issue I've got it.
I'm sorry, my lady.
Wait a minute.
The clue where that is. Where have you got it?
I've got it here.
Where is it in the book?
Well, if you get it.
And the questions which...
Let me just find it.
Sorry, my lord.
1, 1, 2, 6.
Here it is.
Okay.
This is a conditional leave to appeal.
Yes, my lord.
What is the foot of the page?
1755.
Yeah, 1755. Oh, that's... add 600 or something.
There's also a 1124, because you seem to be 2 pages behind the MS.
Oh, no. Well, we don't have.
Yes.
I have found it
2
very
from the MS.
confusing, my lord.
1124.
1124.
Those are submissions.
Yes, the submissions. That's right.
Right, yes.
And there were specific questions that your lordships would recall under the Constitution and the order in council, where there's an appeal, an application for leave to appeal. The Court of Appeal determines the questions which their lordships in the Privy Council would determine. And the questions, when you look at Roman numeral paragraph 19, 1 to 4. 1 to 4. 1 to 5.
I see. So you say we're
These are the questions which the appellants defined. They applied for conditional leave. And these are the questions which they ask your lordships to decide. And therefore, it would be setting a precedent for the Privy Council on the hearing of such an appeal to raise on its own motion a point which was never taken or never raised on appeal.
Yeah.
And the Court of Appeal in Trinidad and Tobago in paragraph 20 said, we therefore consider this appeal to be exceptional. It's public policy, and it's because of the questions which are raised. So, my lords, with the greatest respect, what your lordships and ladyship have to decide is whether the Court of Appeal was right in saying that the claim was automatically struck out. And that is the issue in our respectful submission which the court, which this board has to decide.
Well, I mean, section 109(7) of the Constitution states that subject to subsection 6, which deals with enforcement, the Judicial Committee shall, in relation to any appeal to it under this section in any case, have all the jurisdiction and powers possessed in relation to that case by the Court of Appeal. So I think to confine us within the scope of the ground on which permission is actually granted may be questionable.
Well, my
it says
lord,
an appeal shall lie from decisions of the Court of Appeal to the Judicial Committee with leave in the following cases, where the question is one that by reason of its great general or public importance ought to be submitted to the Privy Council, and that seems to be the basis. But then there's the enlarging provision giving us all the powers of the Court of Appeal in relation to the case.
yes, but my lords, in exercising that power, your lordships have to consider that the appellants consciously decided of the issues which are to be raised.
Yeah.
What happens if this court comes to the conclusion, Mr. Maharaj, that points that have been identified simply don't arise?
The points which have been identified.
Yes. They are utterly unnecessary to the resolution of this litigation. What happens if we should come to that conclusion?
Well, my lords, in my respectful submission, the court has to decide whether the claim was automatically struck out or not. And that's the end of the matter.
I mean, we can't come to the conclusion that I've just adverted to. Maybe you're right, but if that's what you're saying, you better
yes,
say
my
it.
lord. With the greatest respect, my lord, that's what I'm saying, my lord.
Well, there's authority, I think, in relation to criminal appeals to this court where there has to be a certification of general importance that you're not confined. I think I'm right on that by in every respect. That may not be an
it's not a good. It's not necessarily
may not be a precise analogy. But what does concern me is section 109(7). You are trying to put the court into a straitjacket. It does seem, on the face of it, once you get here, then in relation to the appeal, we have all the jurisdiction and powers possessed in relation to that case by the Court of Appeal. And the Court of Appeal could undoubtedly say, forget these issues of general importance, this case should be decided on another basis, which is open.
My lords, I would ask your lordships to consider that this is a special kind of case. This is a case in which a particular issue was raised in relation to an important point of practice and procedure.
Yes.
And their lordships in the Court of Appeal have asked your lordships to determine that issue.
Yes.
And this is an issue which would arise from time to time.
Well, I don't suppose any of the parties are here because this is a fundamentally important point on the rules of the Supreme Court of Trinidad and Tobago. They're here for their own interests, aren't they?
But it came here because their lordships consider it's of exceptional importance.
Yes. I mean, you would say, I imagine, Mr. Maharaj, that there's a good deal of concern in Trinidad and Tobago, and has been for some time, about keeping cases moving.
And my lords, I do not want to go into the merits of the case. I do not want to go into the merits of the case, but at the central powers of the case, of the CPR, is the Case Management Conference. And therefore, this issue is of great importance for the legal profession in Trinidad and Tobago.
Yeah. But if you look at this case, I mean, the issue is, it arises in a context where it's difficult to regard a case management conference, even if there wasn't one, as of any significance at all. It's quite obvious that if anyone had applied for a case management conference, if they'd thought for a moment it was necessary, the answer would have been, good heavens, we're having settlement negotiations, adjourn that with everything else. or fix a date at the same date as the other matters were coming back. And that's the problem with this case. It doesn't look as if there's any real importance about a case management conference if there wasn't one at all.
Well, my Lord,
or anything to have one about.
But my Lord, with the greatest respect, the rules as a case management conference in England and Wales are totally different.
Oh, we accept that.
To the concept in Trinidad and Tobago.
Yeah.
And the CPR, in relation to that particular part of the CPR, was drafted on the basis of the litigation culture in Trinidad and Tobago. Yeah. And therefore...
We know, we've got...
Yes.
We've got the picture.
Yes, my Lord.
Yeah. Well, anyway, that's very helpful. Is there anything more you want to say?
No, my Lord.
We better keep this case moving.
Yes, my Lord. I'm much obliged, my Lord.
Let's just hear what Mr. Brindle says.
Yes, I can be very brief, my Lord. I think the main point is simply what is meant by this so-called withdrawal. And it seems to me, with respect, that it's possible to say that what was intended, so far as one can work out what was going on, is simply that the application was not moved because there was no basis on which to move it. The word withdrawal was used, of course, I accept that, and my learned friend Mr. Knox has shown you the reference in the order of Mrs. Justice Charles. But that doesn't necessarily, he seems himself to accept that what the precise word withdrawal means may be open to some debate. And it seems fairly clear, I would submit, that when the matter did come back to the Court of Appeal in the passage that my Lord has referred to at 287 and 288, when Mrs. Peake was addressing the Court, that she did actually say that there was an application to have the matter reinstated at line 22 on page 288. Now, it's true that she's rather thrown off that by the judges in the Court of Appeal who say, well, it was withdrawn, but her approach is not a surprising one, on the basis that there hadn't been an application that had actually been moved because there was no need to move it. Now, for the first time, Mrs. Peake knew that she had lost. There'd been no intimation beforehand that they were necessarily going to lose, but here it is, they've lost, and so the question of having the matter reinstated comes back in.
I'm sorry, which MS page are you on?
288.
Page 288, sorry.
Doesn't know then she lost.
Yeah, sorry, this is the end of yes, this is the end.
My 288 is...
She may have had an inkling.
Yes, it's not after the judgment, no. It's pages 287 to 288. Does your Lordship want the...
Thank you.
1541 is the MS number.
That's what
Subject to the possible slippage of 2.
No, that's right. I've got it now.
But anyway, this is the only time at which any consideration is given to what will happen if the automatic strikeout is found to have happened, and that's the passage I've just referred to at line 22. Then she's rather thrown off that by the court, and of course what then happens, just to clarify my Lord Briggs's question, we did then, after this, make a new application, a fresh application, to reinstate, to have the matter reinstated. That was supported by an affidavit. That did go before the court, and the court decided that the matter should be adjourned pending this appeal. So that is something else, which is, it's there, and obviously that was the logical thing to do, having in the circumstances, because now for the first time the question of relief from forfeiture or relief from sanctions became important. And I'm not quite sure why. I think your Lordships could, in my submission, either treat the original application, despite the fact of the use of the word withdraw, as still in fact being alive and entertain it, or, because you have all the powers of the courts below, you could entertain the new application. That's possibly slightly more difficult. But
that may be a bit ambitious, yes.
Well,
because it hasn't been, yes, anyway.
Not if we were putting ourselves in the position before the appeal.
Correct.
It was after that.
Right. Right.
I'm not sure I can say much more.
Good. Well, we'll retire for a moment. There's nothing you want to say in reply, is there, Mr. Knox or Mr. Maharaj? No. Thank you very much indeed. On the No, that's helpful. Right, we'll retire for 5 minutes. Right, we're grateful to Council. We are better informed about the position, and we will undertake to hear submissions on the points of exceptional importance which the Court of Appeal has submitted to us while reserving our powers to act under Section 109(7), expressing no view on the submissions we've heard at this point until judgment, therefore. So, Mr. Brindle.
Yes. Lord, in view of the position, it may be I can take my submissions shorter than I was going to, not because I assume anything, but simply because the time had quite a lot of time.
Well, you will have to slightly abbreviate them, but you can be assured that we have digested the intricacies of
I know, well, that's
argument.
why I'm saying it, yes. So, some of my points I may simply state and then, without developing them longer than I need to. So I will attempt to be short. I was going to be perhaps as much as an hour and a half, but I can probably do it in less time than that, given the Court's position. So I was going to make my points under 10 heads. I'm not going to evaluate them in advance. But the first point is what is made a lot of by my opponents in their written cases, which is the particular Trinidadian culture points.
Well, we've got all that.
You've got all that, yes.
I mean, we understand there have been lamentable delays. There have been, of course, in this jurisdiction also, but it was a particular problem which was addressed eventually resolutely in 2005.
Yes, and I'm not saying please take a soft view of serious sanctions. I'm just saying that this particular rule does not apply to the particular facts in this case. You'll have noted in the decision on conditional leave given by Justice of Appeal Jamadar that he actually says there is no particular Trinidadian culture point here, just so that you have the reference to that. It's at page 1126 in the second volume of the report. I'll give you the other reference number in a minute. It's MS number 1126 to 1128. And in paragraph 20, he says, we therefore consider this appeal to be exceptional, that is outside the general policy stated above, which is not to allow procedural appeals. And note it's driven more by pure questions of legal interpretation and application rather than circumstances of local conduct or conditions.
Yeah.
So there's nothing about the magic of a CMC which is particularly peculiar to Trinidadian local conditions. So I won't say any more about that. Lord, on the question, second point of 10, there is some debate, but only very limited, between the parties about the proper approach to construction. I will just read into my submissions our submissions at paragraphs 8 to 12 of our written case. The principal case that seems to be relied on both sides is the Quinta Valley decision. And we see the quote from Lord Bingham there in that part of our written case. And that it has actually been itself adopted by the Trinidadian court in the Mirage case, which comes immediately after that in paragraph 9 of our submissions. And I won't waste time by going to those cases. They're in the authorities bundle. And the only other reference I would make would be at paragraph 13 of our written case, the decision or the speech of Lord Nichols in Inco and First Choice. I think the only difference between the parties is that the other parties say, well, the meaning of these words is plain. And indeed, at one point in paragraph 5 of its judgment, the majority says, really almost seems to suggest there's no point of construction at all. Well, there's a difference between a plain meaning and a literal meaning. Just because the words have a literal meaning doesn't necessarily mean that is their meaning. My short submission is quite simply this. There is undoubtedly a point of construction here as to whether or not the Rule 27, or Part 27, 3.3 and 3.4, the automatic strikeout provisions, do or do not apply in a case where there has been fixed a date at which case management directions can or are likely to be given. There's no doubt that is a point of construction, and you can't say, well, simply the words are plain. That just means the words are literal. So I come, and this is my third submission.
That's what you want to read into it, is it, Mr. Brindle? Well, if it's a matter of construction, you've got to say what it actually ought to say.
That's my next point.
Very good.
Which is to define exactly what the point is. And I would be happy to define it primarily in the way that Justice of Appeal Raj Kumar does in his dissenting judgment at paragraph 22, which is shortly before where I was a little while ago. MS page number 1098 or 1096, I'm not sure which it is.
Paragraph 22.
Paragraph 22. He simply says that the rule must be interpreted as requiring an application for a case management conference if a date does not already exist and which directions for case management can be given. So I'm quite content to adopt that approach, that if there is in fact a date already fixed at which directions, when it comes on, for case management can or are likely to be given.
Is can enough? Because that would apply to almost any hearing, wouldn't it?
I would suggest can is enough, and I will develop that.
Okay.
But if I'm wrong about that, are likely to be would be an alternative. And anticipating my submission on this, we say that in fact, in this sort of a case where you have an interlocutory application coming on for judgment, it is in fact absolutely standard to give case management directions, and it's really quite inconceivable, either in England or in Trinidad, that it wouldn't happen. So I accept there is a difference between can and are likely to, but I suggest it doesn't make any difference here. Now, just to summarise, and this is still the third point of what the actual issue is, the majority go wrong essentially because they say, and I'll just give you the paragraph references without going to them. They say at paragraph 49 that there is effectively a complete code for case management conferences set out in Part 27.3. And they stress the importance of the event. That's a word which they use a number of times in paragraphs 27, 34, and 63. They stress that it is of great importance to have an event, effectively what I would call a formal CMC or a designated CMC, and that if there is no such thing, then in every single case, failure to fix that sort of CMC is fatal and the matter is struck out. I think the only exception would be if the court had actually dispensed with the CMC. I think that's the only exception. Now, we say this is absurd and wrong, and I will now develop why it is. Now, your lordships may or may not have looked at a very important recent case in Trinidad, decided, in fact, after this case, yes. In a case which I will call Syscon, which one of the judges in the present case, Mrs. Justice Jones, was a member of that court, but for present purposes, leading judgment was given by Justice of Appeal Jamadar, who also dealt with conditional leave in our case. And it's in the authorities bundle in various bits and pieces. Tab 8, which I don't think I need ask you to look up, is the judgment of Justice of Appeal Barrow.
Yeah.
And he basically agrees on this point with
Sorry, can I have an MS number, please?
Yes, sorry, 1852.
Thank you.
In the authorities bundle. That's the judgment of Barrow, Justice of Appeal. He, on this point about case management conference, he agrees with Justice Appeal Jamadar, with a slight difference which is of no relevance for present purposes. And you go right to the end of the bundle, MS page number 2108, my lord. You have the judgment of Jamadar, and then you have the judgment of Jones in the final tab. Now, well, the point that was at issue in this case, as I say, it came up after the Court of Appeal decision in our case, was that there is a rule, Rule 20, in the Trinidadian Code, which says that after the first case management conference, it is very difficult, or it is difficult to make amendments to your pleadings, and you have to justify, if you do so, after the first case management conference.
Right.
You have to justify it. That's Rule 20. We can look it up if need be, but I don't think we need to immediately. And that's given rise to quite a lot of difficulty in the Trinidadian cases, because what happens is you've had CMCs which have gone through various adjournments. So you have 6 or 7 of them, and then somebody says at the end, well, that's just the end of the first CMC, and somebody else says, oh no, it wasn't the first one.
Right.
And that was the point which had to be considered. That's a different point from ours. However, in his judgment, Justice of Appeal Jamadar sets out some very helpful and important observations about what a case management conference is in the Trinidadian rule. So if I could take you to paragraph 11 of his judgment. Page 2112, I hope, my lord, is the page number. See, 11.1, what is a case management conference? And he says at 12, the rules provide for 2 core case management functions in the context of the non-bifurcated system that's currently in operation. First, case flow management. Secondly, active judicial case management. And then he sets out, which I won't read, pretty well the whole of parts 25, 26 and 27, and the crucial paragraphs are 17 to 20, which I think I should read because they are of importance. So he says at paragraph 17, of significance are the following. Firstly, case management can be entirely dispensed with. Second, a case management conference can be adjourned or the date scheduled varied. Thirdly, the orders prescribed are not exhaustive of all the orders that can be made at a case management conference, though they are an essential checklist of the general types of orders that ought to be considered. Therefore, in answer to the question, what is a case management conference, the CPR 1998 responds conceptually. That is to say, a case management conference is a court hearing at which a CPR judge actively manages a particular case in furtherance of the overriding objective by carrying out any of the 13 actions listed in 25.1 or the 22 actions listed in 26.1 and make such orders and give such directions as are necessary, including those set out in Rule 27.6, all of which are not exhaustive of the actions that can be taken, directions given, or orders made in the exercise of active judicial case management, so as to advance the matter towards a just disposition. In my opinion, active judicial case management occurs whenever a CPR judge deliberately exercises any of the above stated actions in purported management of proceedings properly before him or her and in furtherance of the goal of a fair and just disposition of a matter. A case management conference is therefore a court hearing specifically scheduled, that's the first case, specifically scheduled for the purposes of exercising active judicial case management in relation to particular proceedings. However, and this is the second point, it is possible that a court hearing or proceedings not specifically scheduled for active judicial case management, that a CPR judge can actively exercise case management powers. Such a hearing would, from a common sense point of view, also be, if only in part, a case management conference. That is because it is the substance of what in fact occurs that matters, not the form it takes. Thus, to determine whether or not there has been active case management, the question to be asked and answered is whether in fact there has been active judicial case management or proceeding by a CPR judge. We say there's no reason not to apply that analysis in the present case. Justice of Appeal Jones
So
did not take quite the same line.
all right, but if you apply that analysis, Justice of Appeal Jamada, when was the first case management conference here?
No,
Was there one?
this isn't the question of the first. Can I come to the first point?
Yes.
Because that's coming in the... I should just read on a bit and then I'll answer your Lordship's question.
Right.
He then deals in the next section with when does the first case management conference start? And that's a question you only ask for the purposes of Part 20, dealing with the amendments that I was mentioning earlier, which was the point in the case. And he says in the second paragraph there, the first case management conference takes place on the first occasion that a court hearing has been specifically scheduled. So to find when the first case management conference is, where you do need an element of predictability, you look at the first scheduled hearing. And he says the same in paragraph 22, third line, the first case management conference as a denotative event marker refers to the first specifically scheduled court hearing of a particular matter for the purposes of active judicial case management. So the first CMC is the first scheduled CMC, but because of what he says in paragraphs 19 and 20, you can have something which is in common sense, as a matter of common sense, he says, and looking at the matter of substance rather than form, that could still be, in a very real sense, a case management conference of some sort. And that would be an example of that would be in the present case, we say.
Well, does that mean that the first case management conference can take place after the first, after a previous case management conference?
Yes, because the first case management conference means, as he says, the first specifically scheduled one.
So
you could have one earlier. For instance, if you have a
It won't be the first one, although it is the first.
The first one, this is a term of art, what is a first case management conference. Perhaps I'll just show you the rule, Rule 20.
I'm with you.
I'll just show it to you very quickly. Yes, it's in tab 2 of the authorities bundle. At MS number 1728. And it's headed Changes to Statements of Case. A statement of case may be changed at any time prior to a case management conference without the court's permission. That's talking about any case management conference. And then the court may give permission to change a statement of case at a case management conference. But then it's 3 that introduces this word first. The court shall not give permission to change a statement of case after the first case management conference unless it is satisfied that there is a good explanation for the change not having been made prior to that case management conference and the application to make the change was made promptly. So that's the rule, sub 3, that was being interpreted in the Seisman case. And the court is saying, perfectly sensibly in my submission, the first case management conference is something designated. You can have, however, because of the general circumstances in which some case management powers can be exercised, you can have that at an earlier date. It's possible. And that's the only way of making sense of what the judge says in paragraph 20 and also what he says in paragraphs 21 and 22. And there is something else in support of that, which is Rule 17.7. If you still have the rules there, can I take you to that now?
Yes.
This is, again, I'll try and get the reference. It's 1717, in fact, so it's right at the end of the part dealing with interim remedies. This is what one would, in a sense, expect, I submit. It says 17.7 in a short rule. On hearing any application under this part, the court may exercise any of its case management powers under parts 26 and 27, and may in particular give directions for an early trial of the claim or any part of the claim. So that's anticipating as one would expect, case management powers being exercised when there is an interim application, such as we had in the present case, as part of that process. And following the approach of Mr. Justice of Appeal Jamadar in paragraph 20, it makes sense to call that a case management conference. Any hearing can be called a case management conference if the judge so decides. And there really is, we say, no difference.
It's not if the judge so decides, if in substance it is.
In substance it is.
Yes. Yes.
It's a matter of substance, not form. The other side seek to say, well, it's only in a sense a case management conference, he's only talking about common sense, but this is an attempt to construe the rule and make sense of it. Now, we say that this is really at the heart of this appeal, because the majority are saying, against me, no, you have to have an event which has to be called a case management conference in order to be a case management conference at all. Whereas I'm saying that is a requirement only, if it is at all, of the first case management conference in the context of Part 20. It is not part of the general rule when we're looking at 27 and the strikeout provisions specifying what is or is not a case management conference. So if you do have, going back to the formulation I tried to give to my Lord of Reviews, if you do have a situation where there is fixed before the court to take place a hand-down of a judgment on an interlocutory application, as there was here, at which it's absolutely obvious that there's going to be case management directions given, as would always be the case, and the judge said in this case it was her practice to do so, as one would expect in England, if it were the same, that there is no reason to say that the case management conference has to be formally fixed as a capital CMC, formally, otherwise you're struck out. And indeed, the fact that it avoids an obvious injustice is quite clear.
I don't understand why you have to go that far.
I may not.
Why aren't you arguing on your submission as to what a case management conference is, as opposed to a first case management conference, that every appearance in front of the judge, or indeed the non-appearance,
not even an appearance.
Yes, you don't. According to Justice of Appeal Jamada, you don't have to have an actual appearance. It's what you have to have is effectively an order.
Well, that is the point I was going to make. My point number 10. I can bring it in now. The judge herself says she was already exercising case management powers.
Yes.
And by that, she's referring to the decision that she made without a hearing when the parties applied at the beginning of March, at the end of February,
yes,
to extend the hearing while they were having settlement discussions. And she decided, this was not the court's initiative, it was the parties. It was my side who wrote the letter, but never mind, it was both parties, certainly the first respondent at least, were entering into settlement negotiations with us, if not the second. And she made the decision to put the hearing off to facilitate settlement. Now, there's not much doubt that that is itself well within Rules 25 or 26.
Well, it's definitely within 20. The Court of Appeal thought it wasn't, but...
well, they did, but they were wrong to do so.
But it was clearly assisting the parties to settle, or fixing a timetable, or otherwise controlling the progress of the case.
So I do say that, my Lord. I say that in the sense...
encouraging the parties as well.
Yeah, I do say that, but I say, if you were... I mean, the Court of Appeal were against me on that. If they're right on that, they're certainly wrong on the other point, where when you actually have a date which is fixed at which you're going to have case management directions shortly handed down, that is plainly good enough. But I do argue the other point, and we've always argued that. Now, my Lord, can I deal fifthly in my of my 10 points, but that point 10 has already been dealt with. Fifthly, there is a point that we make, which the other side attack quite vigorously, about the words in 27.3, the general rule. don't know if your lordships have noted that point. Can I take you back to the wording of 27.3 itself, which I haven't actually
Definitely
done.
noticed it, yeah.
But it's still, it looked at in the rules generally, it's 1737 of the MS numbers. And you see that 27.3 starts out, the general rule is that the court office shall fix a case management conference immediately upon the filing of a defence to a claim other than a fixed date claim. And then it goes on. The second, subparagraph 2 is not quite so important. That's dealing with two defendants. You just note that as we go. But 3 is the crucial follow-up. If the court does not dispense with CMC or give notice of a case management conference within, then various dates are then given, then the claimant shall, within 28 days, apply, and if he doesn't do so, automatically struck out.
Right.
We say, I stress that I don't suggest my whole argument depends on this point, but I suggest it helps. The reference to a general rule is itself saying this is not absolute.
Runs through to 27.3.3, does it?
Well, 27.3, we say that is the general rule. 27.3.3 is the consequence of the non-operation of the general rule. It isn't the exception to the general rule.
How can an automatic strikeout be a consequence that follows only from a general rule? You've got to know whether it's been struck out or not, haven't you?
Yes, you do, but all of this is, we say, covered by the general rule. So the general rule is the court should fix the court office should fix it. If the court office doesn't fix it, or the court doesn't fix it, then the party should fix it, and if that doesn't happen, then you're struck out. All of that is the general rule. This rule is envisaging an exception, at least one exception, to the general rule, which is simply not covered by any of this.
I see. So we have to decide ourselves, rather than from the wording, what the exception is.
Well, my submission is this ties in with my general approach to this rule. Although this is laying down an automatic strikeout in a case where there is a failure to follow 1, 2, and 3, that is not intending to be exhaustive as to all cases dealing with case management conferences.
Well, when 27.3.1 says the general rule is the court office shall fix a case management conference, is that referring to the sort of specific fixing of a date for such a conference that Justice of Appeal Jamadar was referring to?
Well, it's obviously thinking that that's just the office is going to do that, so it's going to be fairly automatic.
Yes. But his alternative was a conference at which case management powers actually were exercised. But the difficulty about that is that until you actually have such a conference, you can't describe it as a case management conference. It's not enough to say that something's coming up where we're likely to...
Not for the purposes of sub-rule 1, I think that's right. No. For the purposes of sub-rule 1, no, I wouldn't.
Yes, I see.
I wouldn't say. Well, this is... We're looking, I haven't brought in the overriding objective yet on the basis on which your lordship should look at preventing injustice, but this reference to a general rule indicates that there is intended to be some flexibility here, particularly given the severity of sub-rule 4.
But taking up Lord Briggs's point, given the automatic nature of sub-rule 4, it's very difficult to have a general rule with no exceptions spelled out at all. Where do they come from?
Well, no, my lady, I think I would say to that there is every reason, if you're conscious of the overriding objective and the need to preserve, you may not know what those cases are, but that there may be some exceptions, not yet perhaps worked out. That's the sort of thing you would do in order to avoid injustice.
Well, it's got to be an exception that operates as a matter of necessity, hasn't it? Isn't one applying some sort of conventional test for implication?
No, I'm just trying to construe why is the word general there?
Well, why isn't it that the general rule is the court office fixes it, and if it doesn't, that's outside the general rule.
Yeah.
Because, my lady, that is not an alternative. That is simply a consequence of the court is supposed to do it. All that 3 is saying, we can ignore, I think, dispensing with it under 27.4. We can put that on one side. But if the court doesn't do it, then the party has to do it. That's not as an alternative. That is just a consequence of the court not fixing it. The court should fix it. If not, the party should fix it. That's all
It's
I submit.
part of the general
That's all part of the general rule. Now, one exception to the general rule obviously is specified in 1, which is a fixed date claim form. So, a fixed date claim form, that plainly doesn't apply. That's spelt out. But I'm not suggesting that that's the only exception, but that would be something. Now, I don't want to exaggerate this point, because my argument doesn't depend on it, but I say it helps. Can I say just a little bit more, coming on to my 6th point, about a point that my learned friends make quite a lot of in their submissions, the need for predictability. They say you have to know in advance what's going to be your case management conference. I think to an extent I've already given my answer to that. That has some force if you're talking about the first CMC for the purposes of Part 20, but it doesn't if you're talking about the broader scope of something which you can treat as a CMC in what I call the Jamadar sense.
Well, what about 27.5? If you have a case, and once it's labelled a case management conference, there are all sorts of consequential provisions, aren't there? One is that you have to be there.
Yes.
Well, you see, lots of appointments before registrars or procedural judges where people aren't expected to turn up.
But in our case, for the purpose of construing 27.3, I would simply say that there is no need for, given the width of what can be a case management conference according to the Jamadar formulation, the need for predictability, although it undoubtedly exists, I can't brush it aside, is not a reason to construe 27.3 in a way which would be otherwise unjust.
The 27.8. There are also restrictions on adjournment, aren't there?
Yes.
Anyway, you make the same point, presumably.
Yes, I mean, that may be case management conference in the sense of a first case management conference or subsequent, first or subsequent, rather than in the broader sense in which I'm putting it.
But I mean, the need for predictability presumably also arises out of Part 20, because a party needs to, if a judge has fixed a hearing at which he's going to hand down a judgment on an interim application, the party probably needs to know whether the time limit for making free amendments is going to end on that day or not. In other words, the party needs to be able to look at the judge's adjournment order or the judge's notification she's going to hand down a judgment and know whether that's going to be a case management conference.
In the context of the first case management conference, yes. Because it's only that. So in the first case management conference that 20.
But if there hasn't been one before, it will hypothesize be a first case management conference.
But all you really need to know.
You can't have an anti-first. I mean, there can't be one before the first, can there?
Well, I think there can, my lord.
Yes, according to Jamadar.
I think there can. I think there can, according to Jamadar.
Yeah.
Yes. I except for the first one, what is called the first one, the first designated thing, that you do have to know in advance, but not otherwise.
And you have to read Justice Appeal Jamadar in the light of the requirement to attend the case management conference as suggesting you can attend remotely.
Maybe.
I suppose you can, but it doesn't seem to be quite consistent with the 25.1J, which is dealing with the case without requiring the parties to attend court. I suppose there's a difference between attending a hearing and attending court. If you can attend a hearing remotely,
I'm sure you can.
by correspondence, can you? I don't know.
Yes, you can.
Anyway, so predictability, yes?
Now, my lord, the seventh point is this, which is Justice of Appeal Raj Kumar's parallel tracks. He says in his judgment that if the Court of Appeal are right, the majority are right, then you have two parallel tracks, and I will suggest this leads to absurdity. You have one track, which is the, in our case, interim application that's been heard and awaiting judgment, at which this judge, in accordance with her normal practice, and indeed most judges, will give case management directions, and case management will take place, even if it hasn't already taken place, as per my debate with Lord Mance a little while ago. Then you have another parallel track altogether, which is the need to fix
case management conference.
Fix the case management conference. What about this? Let's imagine that what had happened in the present case is this, that there hadn't been an adjournment of the hand-down order in the interlocutory application for such a long time. That the adjournment was until May. The day of automatic strikeout was the 4th of April. So imagine that before you get to the automatic strikeout date, the judge had handed down her judgment and had given the very same case management directions as she actually gave in June. You'll see that in June she actually gave a whole load of case management directions. On the majority view we submit, and can't see an answer to this at the moment, the effect of 27.3, if the majority are right, would be that the matter would be automatically struck out, even though the judge had, at something not called a case management conference, but at something where case management was done, had made elaborate case management decisions.
Isn't it a rather unlikely scenario? I mean, if a properly trained judge who understands the rules, which I'm sure all the judges are and do, makes comprehensive case management directions at the end of an interim battle, surely she will simply dispense with the need for a CMC or say we're going to treat this as the CMC.
Yes, but that assumes that the court knows what the automatic strikeout date is going to be that has to be avoided.
Well, she'd do it anyway, wouldn't she?
I don't doubt whether she would unless somebody had pointed it out to her. I mean, when the parties, my lord, agreed here that they wanted to put the hearing off from March till May and then on from May till June, they, I'm sure, weren't thinking about automatic strikeout. I mean, the respondent may have been. I'm sure, I don't know what stage that it occurred to them, but we certainly weren't, obviously.
Yeah.
April, by the look of it, but well after.
Yeah,
but I mean, it does depend, doesn't it, on the magic of adding to your order. Dispense with the case management conference under 27.4. That works, and nothing else does, if they're right.
I would submit to my Lord Briggs, it isn't that unlikely to happen. It isn't that unlikely to happen.
Well, I was just addressing your example where the directions had actually been given.
Yeah, well,
rather than when there's going to be an occasion on which they might or probably will be given. I mean, if a judge has actually handled an interim application by, if you like, bolting on a CMC at the end of it by simply giving comprehensive directions with everybody's consent,
well,
why wouldn't the judge dispense with the CMC?
The judge may have said here, she wouldn't give us, let's imagine the judge had said, when we asked in March for an adjournment,
yeah.
she had said, well, I won't give you as long as you want, I'll just give you a couple of weeks.
Yeah.
And then I want to give my judgment on the interim application. I'm going to give it on 31st of March or something. No one's mentioning anything about 27.3 or anything like that.
Yeah.
It's completely quiet. The judge comes along, gives her judgment. No one says, please treat this as a case management conference or please dispense with it. Just what would normally happen, certainly in my experience in doing cases every day. The judge just says, well, time for defence, time for reply, time for witness statements, blah, 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 goodbye, thank you very much, and walks out of court.
Well,
now, that is not that unlikely to happen.
No.
The history of appellate litigation is littered with cases where judges have forgotten, or the parties have forgotten, to tick a box.
Yes.
Which in this case would be the box marked dispense with case conference.
Would be, so it could easily happen. And it does, in my submission, I don't want to keep on repeating myself, I'll finish the point now. It does show that there's something fundamentally wrong with the Court of Appeal's decision is, because it's the parallel tracks point. You cannot have these two parallel tracks. And that's why the Raj Kumar formulation of saying, well, if you do have a hearing fixed, at which case management directions are going to be given, the whole automatic strikeout under 27.1 and 27.3 just doesn't happen. There's the point. Good or bad. Now, three more points, although one I think I've, in a sense, made. I think I'll just put that one to bed now. Of course, on the other way of looking at matters, the judge had already exercised case management powers, and that itself was enough, as per my debate with Lord Mance earlier. That itself is another perfectly good way for me to get over this. Because if the court has exercised case management powers, or even if it's only one of the list of items, then it must be utterly absurd to say that the failure to issue or fix a case management conference leads to automatic strikeout.
That's the adjournment by consent, is it?
Yes, it's the adjournment by consent. And the Court of Appeal's answer to that is just to deny, which is rather surprising in my submission, that she was indeed exercising the power she thought she was exercising. I'm not sure they had any real business taking that view.
But take an ordinary action. This is a very odd kind of action for the reasons we all know, because there's probably never going to be a trial. The relief claimed is
it's all
like
in aid of
interim
arbitration.
by nature.
Yes.
But take a perfectly ordinary action, a large debt claim, coupled with an interim application for a freezing order. Now that freezing order is bound to be adjourned off from time to time, because it will be made initially ex parte. There'll then be a return date on notice, at which, generally speaking, the defendant will turn up and say, I want time to put in evidence. So the judge will give directions. He'll give the defendant time for evidence, the claimant time for reply, and will adjourn off the further hearing of the freezing order until all that's happened. But they wouldn't be case managing the trial. They wouldn't be case managing the substance of the case towards a trial. They'd just be dealing with the interim application. So how do you find what kind of case management power, must it go in some way outside the purely interim proceedings? I realise this is the most odd case for it to arise in, but just take an ordinary case as a sort of starting point to see how the rule's meant to work.
Well, all rules, parts 25 and 26 are enormously wide. They cover it.
Yes.
I don't think Lordship is just managing the application.
No, I quite accept that you will almost certainly find something within those rules which empowers the judge to manage an interim application.
No.
But nobody would think in the ordinary course that just because the judge had conducted some early, relatively rudimentary and emergency management of an application for a freezing order, which started out ex parte, on the first return date, that there'd been a case management conference. Pleadings wouldn't have been exchanged. Nobody would have given any thought to what they wanted in terms of witness statements and expert evidence at trial. None of the sort of considerations that arise at a CMC would have been even thought about at that stage.
Well, I think I would have to submit that the rules are wide enough to cover not only what Your Lordship suggests are the normal...
Well, I accept they are, but why does that mean that rushed bit of case management at that stage is the CMC?
Well, because we go back to the whole purpose of this automatic strikeout rule is to make sure that parties get on with the case. And if the case is being got on with, because the court are making, albeit some early case management decisions, and not things like trial.
Well, just follow this story on it.
The purpose of the rule is dealt with.
Well, suppose there's an early return date of an ordinary freezing order application. The defendant's given time to put in evidence, the claimant has time to reply. And before the defendant puts in evidence, takes sensible advice and says, OK, here are terms on which we'll undertake not to deal with our assets pending trial. So they write to the judge saying, it's all right, all agreed, and then the case needs to go to a CMC if it's not to fall asleep, doesn't it?
Yes, I agree. The cases can always fall asleep at any stage.
Yes, but not once you've had a full CMC, where generally speaking, a trial date will be fixed, or in some jurisdictions a trial date, I don't know whether it is in Trinidad and Tobago, but certainly a programme all the way to trial will be laid down.
Well, 27(4) is an extremely onerous and severe provision, which is meant to deal, I respectfully submit, and deal only with the case where the case management process has not begun and is not about to begin.
It's meant to deal with a case where the case management conference has some point. Personally, I don't understand what there was left in this action once the judge had indicated that she continued the injunctions and dismiss the application to set them aside.
But she gave directions, other directions.
What other
I was
directions?
trying to remember what they were.
What other directions did she give? Well, that's right, but she only gave that. She only gave that because the whole thing had become rather acute.
Yes, she said it's page 362. Permission is granted to file and serve a reply, standard disclosure.
A reply?
Inspection of documents.
Yeah.
Oh, I see.
Usual stuff.
Read statements of facts and statements of issue. Claimant to file and read bundle of documents. Parties are to file and
But there seems to me a complete, as I understand it, this application was made for freezing relief under Section 31 of the Arbitration Act, which gives the court the same interlocutory powers as it would have in relation to its own proceedings if there was a substantive issue. So that once you've exercised the interlocutory powers, that's it. The substantive issue.
One other aspect to the case.
Well, there's a bit mortgage, but that
Yes,
that had gone because they agreed in January that they would withdraw the mortgages, didn't they?
No.
Oh, that's wrong, is it?
They had cancelled the mortgages, and they agreed to cancel that. But it still remains now something that we need to achieve in this action to get rid of those mortgages.
Yes, but it goes, because that's in aid of the moreover, isn't it? The reason you want the mortgages cancelled is so that there are some assets to freeze.
That is correct. It is, but it's a separate part of the relief. It's not.
Well, yes.
There's the
I see
ravers and there's the getting rid of the.
You have to do something more, do you? I thought the mortgages
cancelled.
were gone.
Is that right? Well, I'm told that it's thought necessary to obtain further substantive relief in the proceedings to formalise the true position of these mortgages. I mean, Lord Hughes is right that it's all part of the overall picture of freezing the first respondent's assets.
Anyway, you wanted something more.
Yeah.
Well, if you wanted it,
Well,
then there was something left.
And I can't imagine why the judge did all that, but she did it.
Well, by then, the point had been taken, hadn't it?
Yes, that's why she did.
By then, the point had been taken. That's true.
Yes, she suddenly thought we better have a bit of...
By then, you see, if you're the judge and you are worried about the terms of Section 27.5, you've got to tick every box in sight, haven't you?
Yes.
Which is
What was the reference to her
undesirable
order?
state of affairs for litigation to be in.
Yes. Yes, here we are. Yes.
Does your Lordship want the direction?
No, I've got it. I have it.
362.
Yes, right. Sorry, now we better hurry you along.
Yes, well, I'm almost done. My last 2 points are, they're largely covered by the written documents. Firstly, the importance of the overriding objective. Now, of course, you can't use the overriding objective to rewrite a rule which is not capable of any dispute. Obviously, you can't. But as soon as there is any scope for argument as to the correct interpretation, the interpretation in my submission should be, and it's the most important point that it should be, looked at in the context of the overriding objective, the most important part of which, quite simply, is the doing of justice. Now, in this case, what has happened is a gross injustice, as Justice Raj Kumar said, because, I think your Lordships have got this point already, the first respondent cooperated with us in discussing settlement and putting off the date for the hearing of the hand-down judgment twice. Firstly in March, and then again for a short period in April. And at that time, they must have known they had in their back pocket this automatic strikeout. But they got us to write a letter to the court saying, please can we have another couple of weeks?
So you make an application for relief and sanctions, and you say, what's more, I should have my cost of this application on an indemnity basis because there are special circumstances justifying a departure
Before
from
one
the
ever
usual.
gets there, surely one should ask whether it can be a right construction of this rule that it, absence of applications for relief, allows this to happen, allows a party, it's trial by ambush, as the judge said. You sit there, you have this point in your back pocket, and you say, oh yes, well, we'll carry on our settlement discussions, and then you turn around and you hope that 3 months go by, because then that gives you another advantage in the period of, because it's only after 3 months that you can, it's only for 3 months that you can in the first instance apply to set it aside. Anyway, we cite in our written case, I won't go to it because of the time, a case called Sibalak. It's a decision of the Privy Council. Sir John Dyson gave a very helpful summary about the role of the overriding objective in this context. So just to give you the reference to it without taking up time, it's Authorities Reference 6, paragraph 24.
Page. Sorry. I can find it.
I can get that for you.
Fine. I'll get my junior to find it while I'm making the last point, which is, 1843. The last point is a constitutionality point. Now, obviously, if I've got that far, you may say I'm getting a bit desperate. I should only say that Jamadar, Justice of Appeal, in his conditional leave, he certainly seemed to think this was an important point, or there might be an important constitutional point about the right to a hearing. It's in our skeleton. It'd be surprising if I failed on overriding objective and won on that, but it is a point which I would not ignore, and I ask you to bear it in mind. All points end up in the same place, which is that this decision is grotesquely unjust, and this court should have no hesitation in overturning it. At that point, I don't think I've missed out anything of huge significance, I hope.
Well, you've done very well. I suspect, well, we seem to be all right in terms of time, if those are your submissions. Mr. Allen, is there anything you want to add? Well, we'll adjourn then until 2 o'clock. Thank you very much indeed.